All right, welcome back, everyone. Welcome back. I can hear you, literally. Fortunately, my ear unpopped yesterday. This one's like maybe like a 10%. So if I go like this, you'll know why. This is my good ear today, but I'm like 90% this ear, so I think I'm feeling mostly better. Well, welcome back. Hope you had a good day. I feel like I saw you so long ago, but so yesterday I was in DC for about 19 hours. It was a quick trip, but the oral arguments were very interesting. And actually, there's a topic discussed yesterday that is very much bearing on something you've learned about. So if you'll indulge me for 5 minutes, I can explain this issue, but I promise you it's actually very relevant to topics we've discussed. So the issue in this case is called King v. Burwell. And here are the facts. Grossly oversimplifying. The way the Affordable Care Act works is that there are these things called exchanges. States were supposed to establish these exchanges where people can go online, buy insurance. What makes these exchanges good is that the government subsidizes them. So if you go to a website for New York or California, you buy a policy, the federal government adds in money. So the price that you see is not the actual price for your insurance. It's probably like half or even a third. And depending on your income, the federal government just adds money directly to that. You never see that, okay? But here's the problem. As we learned last week in Prince v. United States, Congress cannot require states to establish exchanges. That'll be what's called commandeering. Remember this, right? Congress can't tell the sheriff to run the background check. Congress can't tell the states they have to make these websites, these exchanges. So Congress said, okay, here's what's going to happen. If your state, Texas, right, and you don't want to build one of these exchanges, we'll build it for you. Okay, so that's why we have healthcare.gov, which if any of you bought insurance under Obamacare in Texas, that's what you use. Texas did not build an exchange. But there's a potential problem, and I'm really oversimplifying here, but I want to get to the constitutional issue. The statute that Congress wrote in the ACA says subsidies are available, quote, for exchanges established by the state. Exchanges established by the state. Okay. So one way of reading that is, as it says, is the only way subsidies are available are if a state establishes the exchange. What does that mean for exchanges established by the federal government? Is an exchange established by the federal government a state exchange? Okay. So this is the statutory issue that the Supreme Court addressed. And I don't want to go too far into the statutory issue because it's very messy and there's lots of different code sections that I don't want to go into. But there's another angle, a constitutional angle that wasn't readily visible but popped up in the last couple months or so. And the argument's like this. What happens if a state doesn't build an exchange and the federal government comes in there with these markets without exchanges, or without subsidies, right? Think about it. If in Texas, the exchange from the federal government disappeared and it existed only without subsidies, none of you would be able to afford it, okay? Insurance would become so expensive in Texas without these subsidies that anyone on these Obamacare markets would lose it. I think there's almost maybe 700,000 people in Texas who have used this. It's a significant number of people. So what's going to end up happening? Those 700,000 people will probably drop off the health insurance market, right? So the entire purpose of Obamacare was to bring people into the health insurance market. If these subsidies were cut, presumably those people would drop out of the health insurance market. What happens then? The only people left in the markets would be those who are old and sick and need the insurance. Okay, so when you have a market with all these old and sick people and all of you young health people drop out, prices go through the ceiling. This is what's known as a death spiral. If you imagine spiraling down to a death where the market collapses. So think about it this way. The federal government went to the states under this reading and said, hey, you guys have a choice. You can either build this exchange or else we will bankrupt your markets. Let me say it a different way. You can either build your own website, your own healthcare exchange, or you can let us do it for you. Oh, and by the way, no one in your state can afford insurance. And oh, by the way, because of Obamacare, all these old policies are going to be canceled, so they can't use their old policies. Was this, under NFIB, coercion. Recall we did NFIB last week. Remember, here was the choice to states. Expand Medicaid. Go to 133% of the poverty line. Right? Remember we did this? And oh, by the way, if you don't expand Medicaid, we'll take away all of your money. Was it actually a choice? Majority of the court said, no, there was no choice. It's like putting a gun to your head and saying your money or your life. Remember this? Here too, under this reading, Congress said, hey, states, go build these exchanges, or if you don't, we'll throw your entire market into a death spiral. We will force it that the only way you can have insurance is through Obamacare. So why is this relevant? If the court decides to read the Affordable Care Act in this manner, they can choose to avoid this constitutional problem. Let me say that again. If the court thinks that this is how the statute would operate as written, right? As written, it'll create these death spirals. To avoid that result of this incursion into the state governments, they can just decide to leave the statute and give subsidies to some states and not to others. In other words, even if the statute's clear, the subsidies are only available to states that establish exchanges, that reading would create all these federalism problems. So to avoid that constitutional difficulty, the court can just say, you know what, we'll leave it as it is now. If Texas doesn't build an exchange, we'll let them have the subsidies anyway, even though that's not what Congress said. This is similar to what the Chief Justice did in NFIB. It's called a saving construction or avoidance, if you will. They will avoid the constitutional issue. Right? So to avoid this incursion to the states' rights, they will read the statute in a way to let states opt out. If Texas doesn't build an exchange, people in Texas still get the subsidies. Okay? Everyone get that. It was a very quick overview, but it's a very unexpected issue. We discussed last week, we did Obamacare. The first case was a constitutional case, but it was resolved on a statutory basis. Remember the Tax Anti-Injunction Act, right? Is this a tax or not, right? Here, it's a statutory case that very well may be resolved on constitutional grounds. The Supreme Court's never lacking for intrigue. And one of the lawyers for the challengers, Michael Carvin, yesterday said something like, Your Honors, we didn't raise this argument. Like, no one argued this. The government didn't argue it. No one raised this argument. And then Justice Kennedy said something like, well, sometimes they do things that surprise you. Yeah, right. Anyway, so this case very well have a very odd constitutional ending. My book still is being written. Every time something else, a new chapter emerges. But the issue will come up, and I will talk to you about it. If not, you'll be out of my class by then, but I'll probably still tell you anyway. Anyway, but I was at argument yesterday. It was cold, but I got a seat, which was nice. The arguments were so important. Instead of going the usual hour, they went 90 minutes. The Chief Justice. See, if you're ever an advocate and you're running out of time, it's like, oh God, I can't wait for this to finish. And his light was about to turn red, and the Chief Justice said, "Take another 10 minutes, Mr. Carvin." At which point they extended the arguments. Justice Rehnquist never let anyone go late. He would stop you mid-sentence. But Chief Justice Roberts will let people go on and add even more time. So the advocacy was very good yesterday. It was a very interesting argument. I'm a little tired, but I actually got some sleep last night, so I think I'll be okay. All right, any questions? I appreciate you indulging me, but this was a really important topic that will affect a lot of people in this room and elsewhere. Any questions? Anything in your minds? Justice Kagan made this one comment where she referred to Obamacare as a never-ending saga, and she's quite right about that. I got at least one more book out of this, if not two. Anyway, actually, so I've actually planned this out. It's a trilogy. The first one was Unprecedented. The second one will be Unraveled. Third one will be Undone. And then if we get so far, Undead for the final one, which is zombie, zombie apocalypse version of Obamacare, something like that. All right, any questions? Okay, very good. Okay, where did I finish up last time? Oh, thank you. Sorry. I'll call you in a minute, Yasmin. Okay, thank you, sir. Appreciate it. I appreciate the honesty. This class is very good. My last class, they always just have to be quiet. No one wants to raise their hand, and I start keeping track, which is even worse for them. No, I remember like who I marked up last, who was the last one to speak. But I appreciate your honesty. Make one less thing for me to worry about. All right, so our topic for today, believe it or not, may be, all right, everyone, calm down. Relax, that's okay. Our topic for today may at first blush seem odd, but I promise you, for any of you who ever do civil litigation, this is probably the most relevant class for the entire year. Why is this the most relevant class for the entire year? Because it's about how you sue the government, okay? It's how you sue the government. And if any of you ever do any work involving civil litigation, plaintiff's work, employment, civil rights, disability, I don't care what it is, at some point, your client will want to sue the state, will want to sue a state official, will want to sue the city or the county. I promise you. You need to understand how sovereign immunity works in order to sue the government. This is something which, tragically, I don't think you're taught in civil procedure, and most people will never take federal courts. So this will be your only introduction to the concept of sovereign immunity, I think, and I hope I'm wrong, but I'm pretty sure I'm right about this. Okay? So today we discuss how you sue the government. Okay? So the first question is, what are the limits of the police power? What are the limits on the state police power? Our last class, we discussed efforts by Congress to put limits on the police power, right? And what were those limits? Those limits came from the Reconstruction Amendments, right? Under the 14th Amendment, Congress has powers to enforce the Constitution. And if a state attempts to violate those rights, Congress can pass laws to fix it. But we saw in our last class that Congress's first few efforts to do this didn't work out very well. We have the slaughterhouse cases, where Louisiana passed a law violating certain rights about the butchers, right? And what did the Supreme Court hold? Nah, doesn't really mean anything. Privilege immunities doesn't mean anything. We did the civil rights cases, where Congress passed a civil rights law telling hotels and restaurants you can't discriminate on the basis of race, right? Seems like a good law. What did the Supreme Court say? Nah, you can't do that. You're intruding onto the affairs of individuals. So today's class will focus on a similar topic. How can Congress restrict the police power of the states, not through passing laws against them, but by allowing them to be sued? Let me say that again. Today's case is focused on Congress limiting the state police power by allowing citizens to sue the states for constitutional violations. There are a couple ways to make the government do something. One way is for Congress to pass a law, which is the supreme law of the land, and states are bound. But the other way is to hit states where it hurts. Money. It's a mantle, right? Money, cash. When you sue the state and you get a judgment that hits the state in the pocketbook, the state won't do that again, probably. Okay? They often do, but they're not supposed to. So for today, we have to discuss how is a state's police power, the state's sovereignty impacted by the ability to be sued. Okay, everyone get the general gist? And in each case today, we'll have different efforts in which Congress allowed or tried to allow citizens to sue states, and the states objected. All right, any questions before I get started? All right, so let's go back to the very beginning. Article 3 of the Constitution, right? And we know in Article 3 of the Constitution, very specific cases are put in the Supreme Court's original jurisdiction. This is the holding of Marbury, right? The Supreme Court cannot expand the original jurisdiction of the Supreme Court, right? So Yasmin, what are the things? It's up here. You can just read it. I'll follow up. What are the things that the Constitution gives the Supreme Court jurisdiction over its original jurisdiction? Good. So, Yasmin, let me ask you this question. When Congress says that, when the Constitution says that the Supreme Court has jurisdiction over these matters, does that tell you that these parties can be sued? Do you think that suggests that not only is there jurisdiction, but these people can be sued? Why? I mean, that's the right answer, yes. But why do you think that's the case? Right, exactly. So the argument goes like this, right? Why would the Constitution list these different groups as having jurisdiction unless they could actually be sued? Do you need this list? Okay, why? So that's what people thought. So we go down now to the very first act of Congress, the Judiciary Act of 1789. Okay? The Judiciary Act of 1789. The Judiciary Act of 1789 specifically gives, here it is. The Judiciary Act of 1789 specifically gives jurisdiction over, my trackpad's busted, so it's doing this weird thing. Yeah. So the Judiciary Act of 1789 specifically gives jurisdiction over this matter. It says, the Supreme Court shall have exclusive jurisdiction of all controversies where a state is a party, specifically between a state and citizens of other states. Let me say that again. The Judiciary Act of 1789, this is one of the first acts of Congress. James Madison was right there, right? It specifically says the Supreme Court shall have jurisdiction between a state and citizens of the other state. Okay? This is permissible within the Constitution because the Constitution says any case involving a state shall have original jurisdiction. Okay? Oh, man. All right, so Elliot, let me ask you this question. When you read this, when the Judiciary Act gives jurisdiction over a state and a citizen for another state, is there any reason to think that a guy from South Carolina could not sue Georgia in the Supreme Court's original jurisdiction? Why not?
Because he's a citizen of another state.
Okay, good. So if you just read Article 3 of the Constitution and the Judiciary Act of 1789, you would lead to think that there's nothing wrong with a person, say, from South Carolina suing the state of Georgia in the Supreme Court. Okay? So everyone get this, right? This brings us now to the case of Chisholm v. Georgia. Now, Amanda, let me ask you a question. Chisholm had a problem with Georgia, right? They owed him some money. We don't really care about the facts, right? But the state of Georgia owed Chisholm some money from some war debts. Okay? Amanda, why didn't Chisholm sue Georgia in a court in Georgia, a Georgia state court? Why didn't he use a Georgia state court?
I don't think that we can sue state court.
Why not? Elliot?
There weren't any state courts.
What?
There weren't any state courts.
Oh, there were state courts. Georgia had courts before the Republic existed. Alana, why do you think Chisholm didn't sue Georgia in a Georgia state court? I'll try it again.
I mean, is it just because they said that they had sovereign immunity?
Okay, that's the right answer. Okay, so a little history. What is a sovereign? What's a sovereign, Renee? You ever hear that word? What's it mean for you, sovereign? Yeah. A little bit louder, but bad here.
A sovereign state, like with citizens.
Yeah, but what does that mean, though? What does it mean to be? What does it mean for a state to be sovereign? Huh?
Like protected from,
What do you think?
to control what goes on within the state. To operate on its own.
Okay, good.
To be kind of like the supreme.
Good. Okay, you're all right. Okay, you are all describing attributes of sovereignty. That's why I called on a lot of people. There's no one good definition of what sovereign means, but generally, first, the ability of a state to govern itself. The state is supreme. You would have heard the word sovereign before in terms of the king. The king is a sovereign, right? Unto himself, he is the state, right? I forgot to say it in French, but if anyone knows, you can say it. I am the state. What is one of the attributes of sovereignty? Anyone ever hear the expression, the king can do no wrong? Everyone's heard this, right? This wasn't just an expression that, History of the World Part 1, right? When Mel Brooks said, it's good to be the king. This is actually a statement of law. The king can do no wrong. As a result, the king cannot be sued. The king cannot be sued. So what happens if you were in jolly old England and the king did something bad to you? Could you go to the court and file suit? No, they'd laugh you out. Your only remedy was the political process. You go to Parliament and you request what's called a petition of right. You'd actually demand the king to basically not admit that he was wrong, but to pay you off what you were due. Okay? How effective do you think this remedy was, Mary? How effective do you think it was, the remedy for the king himself to admit he was at fault and give you money, whatever he owed you? Right, what's the check? So generally speaking, when the sovereign did something wrong to you, your only remedy was a political process and hope that the king's honesty, character, accountability would mean he would do the right thing. So we know the king wasn't very good with those kinds of things. We fought a war over it, among others. But what happened in the United States? Were the states sovereigns? So this is a topic that's actually not historically clear. But we've discussed in many respects that when Declaration of Independence was signed, when we declared independence, whatever sovereign power the king had descended to the states. Remember, we've discussed this concept a few times before. That whatever powers over war making, over making treaties and other aspects of international law that previously are held by the crown, devolved to the states. Okay? So before the Declaration of Independence, the sovereignty was with the king. The declaration, the sovereignty went to the states. But then something funny happened. Crystal, who has the sovereignty in our Constitution? Is it the states? The people. The first three words, right? We the people of the United States. Not we the people of Georgia and South Carolina and New York. It's we the people of the United States. So there's actually a legitimate debate, and people have been arguing about this for 200 years now, right? Where is the ultimate sovereignty in our Constitution? Do the states retain the sovereign immunity that was held by the King of England? Or is the sovereignty held by the people themselves? And the reason why this matters The reason why this is very significant is because when you have sovereign immunity, it means you can't be sued without your consent. But if you don't have sovereign immunity, you can be sued just like any other person, right? If, Jason walks up and punches me, right? I can sue him for battery. I can go to court and sue him. What if Jason was, I don't know, the governor of Texas? Could I sue him then? What if he was a federal official? Could I sue him then? If he was acting under state law and he was, a cop beating me up? So the issue of sovereignty matters because once you attach this sovereignty, that person is no longer a litigant in the same sense he and I would be. They take on a different level. Okay? So our very first constitutional debate in the Supreme Court, this is one of the first Supreme Court cases of any importance, was 1793. 1793. Friends, this is 4 years after the Constitution was ratified. 4 years. 4 years after they came to agree what the damn thing means, okay? We're sitting here 225 years later trying our best to figure out what this thing means, and 4 years later they disagree, okay? One aspect of the case which is going to be confusing for you is how the opinions are laid out. John Marshall did a lot of great things, but perhaps the greatest thing he did was called the majority opinion. I know all of you are still used to saying, okay, here's the majority, right? And here's the dissent. So you know what the court held, you know what the dissenters held. Before John Marshall, that wasn't done. Judges issued opinions called seriatim. S-E-R-I-A-T-A-M. Seriatim. What that means is each judge will write his own opinion separately. And then it was up to us to try to figure out what the most narrow holding was. That will drive you crazy. Okay? That will drive you crazy. So I think here, were there 5 opinions? What's the majority opinion? Well, the majority opinion was that 4 judges agreed that Georgia could be sued. 4 of the justices of the court agreed that Georgia could be sued. They didn't exactly agree why Georgia could be sued, but a majority of the court held Georgia could be sued under the Constitution. Okay. But what's more interesting is we might call the dissenting opinion from Justice Iredell. Because Justice Iredell's opinion, finding that Georgia cannot be sued, would ultimately prevail. So I want to start by going through not Iredell's opinion, but the other ones. Blair, Wilson, Cushing, and Chief Justice Jay. Hector, walk me through, what's the general gist of the opinions of the other 4 judges, not Iredell?
Well, most of them have a plain language reading of the Constitution and say that it's pretty clear by the language of the text that a state can be sued by this and that different state.
Yeah. So look, yeah, you're exactly right. So we look at the text, right? We look at Article 3, and we look at the Judiciary Act of 1789. Hector, is there anything in Article 3 which would suggest that this principle of sovereign immunity exists and a state cannot be sued? Is there anything in the Judiciary Act of 1789, first Congress, that will suggest that a state cannot be sued?
No.
In fact, the exact opposite's true. It specifically authorizes jurisdiction for a suit with a citizen of another state versus a state, right? Why would Congress give this jurisdiction if the state couldn't be sued? What sense would that make, right? Why would Congress allow a state to be sued? Right? But here's, if I can defend the dissent for a bit, right? Connie, this says here between a state and citizen of another state, right? What does that say?
A state shall be party.
Okay, let's be really specific here. Does that mean the state's getting sued, or the state can sue someone? Does it specify?
No, because you could be one or the other.
Okay, so here's actually the other argument, right? This specifically says a state and a citizen, right? All this says is a state shall be a party. So maybe the framer said that the states themselves can sue people. Maybe the framers only wanted the states to be the plaintiff, not for the states to be the defendant. But when you frame it like this, the states can be the defendant. Everyone follow that, right? So actually, the Article 3 argument isn't entirely conclusive, but I think it's granted that at least this language allows the state to be defended. It may not be the only way. Okay? There's also interesting discussion about how the United States should look to English law. And a number of the judges say, wait a minute, guys, this is America, right? This is America. We don't look to this fancy international law. We don't look to what those Brits who just fought a war against think, right? We don't have a crown. We don't have a sovereign king. The states are not sovereign. The states are places. The sovereignty is in we the people, each and every one of us, right? Not we the people, plural, right? We the people, everyone, individuals, that the people who voted for this Constitution are sovereigns, right? They also make one other point, Aleda. Who ratified the Constitution? No. Who ratified the Constitution? Yes. It was not the state legislatures that ratified. Each state had conventions, right? Constitutional convention, which were made of just random folk, regular people, right? This is actually a weird historical quirk, which I'm trying to research. So actually, the time the Constitution was ratified, women held the right to vote. It was a very brief period. It was actually removed later. And I've been trying for years to find any record of any women in New Jersey who actually participated in a ratifying convention. I've been trying for like 6 years. I haven't found it yet, but I'm going to try because they were eligible to vote and they would have been eligible to go to the convention. Anyway, but yes, it was the people who were able to vote. And it was the people of Georgia who ratified the Constitution as well. So in that sense, Georgia itself, its own people, joined the Constitution knowing that their state could be subject to a lawsuit, right? That the people of Georgia knowingly ratified a document that said the state can be subject to this lawsuit. So the 4 judges held, listen, you guys can't complain, right? You joined this Constitution and you ceded your sovereignty, right? Whatever sovereignty you had, the Declaration of Independence, you gave it up to the United States of the people. Everyone see that? Okay. So Michelle, what did then Justice Iredell say? What we might call the dissenting opinion. What was Iredell's argument?
He has a less strict reading of the Constitution text.
Uh-huh.
And I think he believes that at the time, I guess the Constitution was formed, they didn't really know about civil states and things like that.
Good.
But he says you have to form, I guess like take things as they come and adjust to the new times.
Yeah, that's good. So basically, Justice Iredell writes in his what's effectively dissenting opinion that in the history of the world, it's never been known to sue a state. This has never been done before. And there's nothing in the Constitution which suggests a change to that, right? In other words, if Congress wanted to radically alter the relations between the states, it would have to speak clearly to that. And because it didn't, because it's basically silent about this, all it says is a state shall be a party, right? Shouldn't we just interpret that to mean the states can be plaintiffs? Why do we have to interpret that to mean the states are defendants? And look, it's not in a reasonable position. This was a serious alteration of how things worked. And I think to Iredell's credit, right? The reaction after this case suggests that Iredell was correct. Because immediately, not like within a year or two, I don't know the exact time frame, but it was pretty quick. Within a year or so, Congress reacted violently to this. They thought, oh my God, this is ridiculous. How is it possible? How is it conceivable that a citizen can sue a state? They said this is a terrible, terrible holding. And as a result, a constitutional amendment was ratified almost immediately to fix this case. That they were so scared by the idea of suing another state, of a citizen suing another state, that the 11th Amendment was ratified. Okay? So everyone turn to the 11th Amendment, please. It's on page 46. It's a short one. It's not very long. Okay? The difficulty, though, of the 11th Amendment is that the words they chose doesn't really reflect what people thought. Okay, so let's read it. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state. Okay, don't worry about the last part. I'll read the important part again. The judicial power shall not extend to a suit prosecuted against one of the United States by citizens of another state. Okay? Maria, just reading those words, right? Just the words we read a moment ago. How would you interpret the 11th Amendment? What does that mean?
That citizens of another state can sue another state.
Good. So could someone who lives in South Carolina sue the state of Georgia? Can someone who lives in Oklahoma sue the state of Texas? Okay. You live in Texas, right? Could you sue the state of Texas under the 11th Amendment? Okay. This is where it gets interesting. And this is why the 11th Amendment's a mess. You're exactly right. If you read the plain text, right, all it does is reverse the Judiciary Act of 1789, right? The Judiciary Act of 1789 says a state and citizens of other states, right? So someone from South Carolina can't sue Georgia. That was the exact fact of Chisholm v. Georgia. So this amendment, by its text, just by its words, and we taught that words matter, by its words, did nothing more than prevent someone from South Carolina suing the state of Georgia. Right? That's all it did by its text. But this creates an odd situation. If the state of Texas breaches a contract against someone from Oklahoma, right? The person from Oklahoma will be out of luck. They can't go to federal court to sue. But if the state of Texas breaches a contract against one of its own citizens, against me or you, we can go to federal court and sue. Even if Texas won't open up its own courthouse, not allow us to sue, we can go to federal court and sue it anyway. This is a weird situation. Adela, let me ask you this question. Why do you think Congress would have allowed this to happen, where a foreigner who gets screwed by a state can't sue, but a citizen of Texas could sue? Why would Congress have allowed this?
To make sure that the state that the citizen lives in doesn't take advantage of that citizen, or maybe allows them to have due process.
But wouldn't the state of Texas be more responsive to its own people than someone from out of state? Right? If you think about it, it should be the other way around.
Maybe it's because they don't want to deal with it because other foreign entities have claims against the state because of the destruction they, did in all the wars. So they're just like, we're just gonna.
So the only people who can sue then are citizens of your own state. So the only Texans can sue Texas, right?
Yeah.
Even though Texas never authorized its own citizens to sue. Now you may think, oh, I love Texas, it's so good to me, right? But Texas doesn't want you to sue. Believe it or not, you can't sue Texas for any reason. Texas will allow you to be sued in its own courts, right? So shouldn't it be the political process? Meaning if I'm a Texan and the state wrongs me, I can vote someone out of office, I can change the law, right? Can I, in theory? What's the person from Oklahoma to do? They can't do that. So this creates a very odd scenario on the 11th Amendment, which didn't matter much for almost 80 years. And the reason why it didn't matter is that, believe it or not, federal courts did not have federal question jurisdiction. You could not sue under a federal question until 1890. That didn't exist. All federal courts had was diversity. But once federal question jurisdiction came in, we get the case of Hans v. Louisiana, 1890. Okay? By the very title of the case, you know that someone's suing a state. That some guy named Hans, a citizen of Louisiana, is suing the state of Louisiana. This is actually a case stemming from, again, basically unpaid interest on a breach of contract. Actually, I ran the numbers. So the amount in 1890 was about $87,000. In present-day dollars, it's about $2 million. So basically, the state of Louisiana owed this guy the equivalent of, let's say, $2 million. And this stemmed from certain debts from the Civil War. And what happened? Louisiana changed their constitution and said, oh, by the way, we're not going to pay these old debts. Okay? Hans brought a suit claiming a violation of the Contracts Clause. We discussed this, right? States cannot violate contracts. That's prohibited. So Hans sued for a constitutional violation against the state of Louisiana in federal court. Okay? So, Whitney, under the 11th Amendment, in Article 3, is there anything stopping Hans from filing this lawsuit? In the 11th Amendment. He's a citizen of Louisiana, and he sued Louisiana. Why not? Very good. The 11th Amendment only stops foreign citizens from suing a state. But if he's a citizen of Louisiana, he, under the 11th Amendment, the text could sue Louisiana. I want to see that. But here's where the court goes off the rails, so to speak. Opinions that pretty much most people think is probably wrong, but it's become so well established in our case law that there's virtually not much of an opportunity to reverse it. But I want you to know that if this seems like a weak opinion to you that doesn't make a lot of sense, you're not alone. Okay? So Tiffany, how did before I get there, Tiffany, let me ask you this question. Why do you think Hans didn't sue the state in Louisiana State Court? Why do you think?
He wouldn't have won. Like, he had no chance to win.
Not even no chance. Why didn't he sue in state court?
Because he wasn't allowed.
Yes. Why was he not allowed?
Was the Constitution?
Yes. Under under Louisiana law, the state courts had no jurisdiction. Louisiana said, our state courts do not have jurisdiction for suits against the states. In other words, Louisiana said, screw you. We are not going to open up our courthouse doors to sue us. If you have a problem with something the state did, go talk to your representative. Go elect a new governor. Right? The political process is used to fix this. Okay? But by going to federal court, he bypassed that process. He bypassed that. Okay? So, Cindy, why did the court ruled that he can't bring this suit, right? But why did they rule that?
I think it mentioned that it was unheard of during the time that they drafted the Constitution that a state could be sued by its constitution, by its citizens.
By any citizen, right? So here's what's happened. This is interesting. This is what we call revisionist history, right? Because we had, the Judiciary Act, we had Chisholm v. Georgia. And the entire case was about a foreign citizen suing a state. That's all the case was about. The 11th Amendment was ratified, and all it spoke about was that a foreign citizen suing, right? Stephanie, let me ask you this. If Congress wanted, if the framers of the 11th Amendment wanted to stop all suits by citizens, regardless of where they lived, what could they have written?
That it was just not allowed
By,
by,
because it says here, citizens of another state, right?
okay, so specifically with the 11th Amendment?
How could they have rewritten this to make it really clear?
Or they could have just said, states cannot be sued
By any citizen,
by any citizen.
period.
Yeah.
Okay, so look.
Or any alien.
Yeah, but anyway, yeah, exactly. Yeah, good. Right. So we have the situation, right? If the framers of the 11th Amendment wanted to say that states could never be sued, they could have done that real easily. All they would have to say, the 11th Amendment, no suits by any citizen or alien, period. End of sentence. They didn't do that. They said, by citizens of another state. Jocelyn, what do we make of the fact that Congress chose, those deliberate words, and those are the words that were ratified? What do we make of that fact?
I took it to mean that they meant for that to be left open. They meant that as a right to be reserved by the citizens that they could sue.
So that a domestic citizen, so a citizen of Texas, could sue. Okay? Now, that seems like a rational argument, right? But Jason, what does Justice Bradley say in response to that?
That the states hadn't envisioned, like they hadn't contemplated the possibility that federal courts would have like powers to sue.
Yeah, exactly.
And he referred to Alexander Hamilton in Federalist 81.
Mm-hmm. Right. So what Bradley said was, okay, look, we know what the Constitution says, right? It is true that the amendment does so read. But he said this would create a, quote, anomalous result. What's this mean, anomalous result, Alejandro?
He doesn't want for a state to be able to get sued without its consent.
Yeah. He's like, it doesn't make sense. So some guy from Oklahoma can't sue Texas, but a person from Texas can sue the state? So he calls this an anomalous result. So he says the 11th Amendment actually was bigger. It embodied this principle of state sovereign immunity. There's a principle of sovereign immunity whereby states cannot be sued without their consent, period. End of sentence. It doesn't matter if it's a foreign citizen or a domestic citizen. His reasoning for this is going back to history, saying, look, the king could never be sued. But wait a minute, wasn't that just the point of Chisholm v. Georgia? Didn't they say we're not English? We don't have a monarch as sovereign. We have sovereign people, not states. So it's an odd attribute that in order to justify this decision, he has to go back saying, this is how the king worked, and we should work in the same way to give the states this type of sovereignty, right? In the end, he says states must consent to be sued. Okay? All right. All right. So any questions on this case? Yes, ma'am. This case? Well, let me ask a question. What do you think the public reaction was? Who do you think would be happy or sad about this?
I think the states would be.
Oh, they were thrilled.
But what I couldn't understand is they kept referencing and saying, this was unheard of. Citizens didn't sue the states, but as you had said, the whole point of, all of this was that we were going to get away from, the king wouldn't be sued. So I just couldn't.
So the important point to make, right, is that after the 11th Amendment, okay, the Supreme Court, I'm sorry, after the 11th Amendment was ratified, Congress basically got rid of federal question jurisdiction. Okay, so there was really no occasion to sue the states in federal court. And it wasn't until I think 1890 or right around this time period that Congress restored federal question jurisdiction. And once that, people started suing the states again. So for a period of like, 75 years, there were really no lawsuits against the states in federal court. This wasn't an issue. If anyone tried suing the states in state court, it would be dismissed. So this change of law allowing federal question jurisdiction brought this out. But to answer your question, you're right. The states, why? States don't like getting sued because it hits them in the pocketbook. They have to defend it, go to court, right? But individuals were not happy because this makes civil rights litigation very difficult. Hector, what's your hand up?
Yes.
Yes, sir.
Can the 11th Amendment be read to even destroy diversity jurisdiction? I mean, it says it cannot commenced by one of the United States.
Well, it's against a state. Commence against one of the United States, so the state is a defendant.
Oh, okay. One of the United States.
Yes, sir. Yeah, no, I think that's a, yeah. So in other words, the United States, a state cannot be a defendant, right? So we get from this case, Hans, Louisiana, which again is wrong, right? This was a probably not correct interpretation, but it's so well established that it's become good law that there's a principle of sovereign immunity, that the states cannot be sued without their consent by anyone, domestic or foreign citizen, by anyone. So what happens when the state does something wrong? Political process. Go through the political process, vote, throw someone out of office, vote someone else in. But we'll see very shortly, the extent of this was fairly short-lived. Okay? Let's take I need to go pop a pill because my ears are still stuffing. Let's take about a 5-minute break. We'll come back. Thanks. Yep.
$80.
Yeah, I know. Like so far,
Yeah, I wouldn't have thought of that. I'm just gonna.
All right, welcome back. Shh. This is why I don't like doing breaks. No one ever's focused afterwards. Anyway, so welcome back. Now I've popped my Advil, so hopefully I'll be a little bit less congested, but I'll be okay. So why am I teaching you this class, right? Why is the 11th Amendment relevant to the topic which we're discussing? Well, the topic we're discussing is efforts by Congress to protect the provisions of the 14th Amendment, the Bill of Rights. So our last class, we did civil rights cases. Congress attempted to pass a law which limited the ability of state businesses to discriminate. Say you cannot have a segregated hotel or whatever else. And if you do, people can sue you or we can fine you. This law, in effect, intruded on the state's sovereign immunity. It told the state, you have to be subject to these laws. You individuals need to be subject to these federal laws. Okay? But in the 1990s, Congress became much more ambitious with this power. Specifically, the power under Section 5 of the 14th Amendment. So everyone, please turn to Section 5 of 14th Amendment. It's on page, where is it?
50.
Thank you, sir. Page 50. Again, when I say Section 5, this is what I'm talking about. It's just called Section 5. Section 5 says, the Congress shall have the power to enforce by appropriate legislation the provisions of this article. Okay? What does that mean? Congress can take steps under the 14th Amendment to make sure that the states are complying with the Constitution. Okay? So the easy example of these involve things like the Voting Rights Act, right? Easy example. Congress finds that states are doing things to suppress minority voting. Evidence that they're imposing, poll taxes or literacy tests, or, we discuss these various mechanisms which are used to suppress black votes. Congress can say, listen, we recognize that you guys are sovereign states. That's really nice, but you're violating the Constitution. You are imposing systems of laws that infringe on the right to vote. So we're going to pass this Voting Rights Act. And under this Voting Rights Act, we're going to tell you what you have to do. We're going to tell you what kind of voter registration forms you can have. We're going to tell you what kinds of ID you can require people to provide. We're going to tell you where you can have your polling locations. We're going to tell you how do you advertise voting, right? In any other context, it will be egregious for the federal government to come in and dictate to a state how they can manage their local affairs, right? I mean, it would be unheard of for the federal government to do this. But when a state is violating a constitutional right, such as the right to vote under the 15th Amendment, Congress has the powers to step in and say, okay, we're going to intrude on your turf. We're going to intrude on your state autonomy. But it's for this limited purpose of ensuring that you comply with the Constitution. Okay? And this is a case called Katzenbach versus Morgan, which is mentioned in the notes. Okay? But what about where it's not clear that states are violating constitutional rights? Right? What about where the states are doing stuff that the Supreme Court says fine, but the Congress thinks is wrong? Okay? And this brings us to the case of Boerne v. City of Flores, which is a case that arose not too far from here. Anyone know where Boerne, Texas is? Anyone know where that is?
North of San Antonio.
Yeah, I think it's near San Antonio. Has anyone ever been to the church there? It's St. Peter Catholic Church. Do you know this church?
I know some of the churches in that area, but I don't know.
Okay, so here is the facts of the case. Do you know the area? If you've ever been to the area? Okay. Have you done zoning yet in property or no? Okay. So generally speaking, right, if you own a piece of property, you can build on it as you wish. But often states will enact various zoning laws that limit the ability of you to build on your own property. Okay? In Boerne, Texas, the St. Peter Catholic Church had this very big building. It fit 230 people. But it wasn't big enough. They had all these people coming for Mass who had to stand outside. There wasn't enough room. So the Archbishop said, okay, we need to expand our church, make it bigger. Okay, sounds reasonable enough. So they filed for a permit with the city to expand and to build a bigger church on their property. The city said, no, I don't think it's a very good idea. You can't do that. It's a historical site. This church is so beautiful. We don't want you to expand it. We don't think it, you have enough people inside. That's fine. So you might say, wait a minute. Where the heck does a city get the power to tell a church they can't build? Well, when you do zoning in class and property, you'll learn that the state can basically do whatever they want. If they call your property historical, then too bad. Your property is worthless. You can't build on it. Okay? That's property law. So under normal property law, if any business asked for a building permit and the city said, no, this is historical, that would be the end of the story. That would be the end of the deal. There'd be no one to sue, right? If the properly designated historical zone, no one to sue, that's it. But this was a church. And the church made an argument. They said, you're burdening our religious exercise. In order for us to tend to our flock, to reach the parishioners who come to our church to pray, we need more room. We can't fit this many people in the building. It's a fire hazard, right? You are burdening our religion. Give us an exception, right? Give us this permit to build. All right? So these are the facts of the case. But before we get there, we have to ask ourselves, does this violate the First Amendment? The Constitution guarantees the right to free exercise. Does this zoning law violate the free exercise rights of the church? Okay? So I need to give you a little bit of a history on the First Amendment here, which is relevant, but it's going to be helpful. For many years, the Supreme Court had an approach to the First Amendment that said, if you have some sort of religious exercise and the government burdens it in a certain way, it's unconstitutional. Government can't do it. I'm grossly oversimplifying because it's going to be changed in a moment. But in 1990, magical year, the Supreme Court changed direction. So the facts of the case were like this. Case called Unemployment Division versus Smith. So you had a guy in Oregon. He worked as a drug counselor for the state. Okay? He was Native American. He was an Indian. Part of his religious exercise was ingesting peyote. Everyone know what this is? These are these like hallucinogenic mushroom type things. I don't quite. Anyway, it's cactus, not mushroom, cactus, right? It's a hallucinogenic cactus. Okay? So as part of his religious beliefs, he would eat this hallucinogen. Under federal law, it's a drug. It's illegal. As I mentioned, ironically, he was a drug counselor. And as part of his job, he underwent drug testing. And he tested positive for peyote. You know, there was no mystery there, right? So what happened next? He was fired, not surprisingly. So he sued, saying, hey, wait a minute. Listen, guys, I know you have a general law saying that people who work for the state can't do drugs, right? And I get that. But listen, this is my religious belief, right? This is if I don't do this, I will have, I will suffer in the afterlife, whatever that looks like, right? So this went to the Supreme Court. And in a 5-4 decision, the Supreme Court held, too bad, right? Too bad. This is a neutral law. This is not a law targeting Native Americans. The law is neutral on its face, right? If the law is neutral, it doesn't matter if it burdens religion, right? It's a neutral law. No one can smoke drugs. They're not targeting religion. Too bad, Mr. Smith. Okay, he actually died in the last year or so. There was another case that proves a different lesson. So ever know what Santeria is? It's like a Afro-Caribbean faith. And part of the religious exercise is these ritual slaughters of chickens. It's ghastly, but they basically slice the chicken's neck. It bleeds everywhere. You can Google that. So anyway, it's part of the religious belief. So the city of Hialeah, Florida, passed a law which effectively banned slaughtering of chickens in city limits, right? Now, if you read the law, it looks neutral. It's like, oh, this is like, a humanitarian law that's meant to save animals, and it says you have to kill chickens a certain way. But if you think about it, this is a law directly targeted the Santeria. No one else killed chickens in this manner. And even though the law looked neutral, the law actually was targeting only this one practice of the Santeria faith. Supreme Court said, unconstitutional. You can't do this. This is not a neutral law. But the key fact there was it wasn't neutral. This was called City of Hialeah versus Lukumi Babalu. Lukumi. I'm probably spelling that wrong, but it's Lukumi something, right? So we have these two standards, right? If it's a neutral law, it can burden religion, right? If it's not neutral, doesn't matter. We look to the intent. If it's not neutral, it's unconstitutional. Congress didn't like this very much. Congress did not like how the Supreme Court interpreted the First Amendment. People like Ted Kennedy, Chuck Schumer, and others said this is very bad. That minority religions like Native Americans or the Santeria, who have these, not common faiths, are going to be targeted by the states and they can be discriminated against. So much like Chisholm v. Georgia 200 years ago, Congress reacted. Now, they didn't amend the First Amendment, right? They didn't pass a constitutional amendment to revise the Free Exercise Clause. Thank God. That would have been a mess. Glad they didn't. But they did something close. In 1993, Congress passed the Religious Freedom Restoration Act. Religious Freedom Restoration Act. If you want to be cool, RFRA, right? RFRA. Preview, this is what was at issue at Hobby Lobby, which we'll discuss in another class. But the Religious Freedom Restoration Act was meant to respond to the Coyote case, the Smith case. Okay? And what it tried to do was to restore the First Amendment before Smith. Remember I said there was this test that you can't substantially burden religion, right? They tried to restore, like Religious Freedom Restoration Act. They tried to bring back the way it was before Justice Scalia apparently messed it up, right, in Smith. Okay? How does this law work? It says that no state or city or any local government can pass a law that substantially burdens religion unless they have a really good reason, right? States cannot pass laws or do anything that substantially burdens religion. That's a key word, substantially burdens religion, unless they have a good reason, right? We'll do this topic again when we do the First Amendment, but I want to introduce it to you now. What happens if a state substantially burdens your religion, such as the church in San Antonio, which was not given its permit? They can go to federal court and sue the state. If a state or city or any local government violates this statute, you can go to federal court and sue over it. So you see what's going on here, right? Congress isn't just giving jurisdiction to the federal courts for lawsuits against the state. They're actually giving a cause of action, saying, if the state passes law, you can go to court and sue. Okay? RFRA was a huge law, but in long and short of it, it allowed people to sue states over actions that violated religious liberty. Everyone get how it works? If you don't, stop me. That's how the statute works. Okay? Sean, let me ask you a question. What about the 11th Amendment? Didn't we just say 10 minutes ago in Hans, Louisiana, that citizens can never sue states? How is it possible for Congress to do this? We just said citizens can't sue states. Why are they allowed to sue states now?
I guess about making that federal issue that allows the citizen to sue on behalf of the government, the federal government.
No, he's not suing on behalf of the federal government. He's suing on behalf.
As a violation, because of a law handed down by the federal government, they're filing suit under that.
Well, I know, but didn't we just say that the jurisdiction, the judicial power, shall not extend to suits by a citizen against the state? Oh, yeah, we just said 5 minutes ago. 11th Amendment says, under Hans, Louisiana, you cannot sue a state, period, end of sentence. How did Congress do this? Well, that's sovereign immunity.
Based on the Section 5 powers.
Good. Good, okay. So this is actually a really fun point, which is very nuanced, but I want you to get. Andrew, so let me ask you this question. Which came first, the 11th Amendment or the 14th Amendment? Which came later? The 14th Amendment revised the 11th Amendment. The 14th Amendment modifies the 11th Amendment. This is kind of an interesting, neat point, right? So the 11th Amendment says, under Hans, Louisiana, no one can sue a state, period, ever. But then we have the 14th Amendment. We have Section 5. And Section 5 says that Congress can intrude on state sovereign immunity to enforce the Constitution. The same way that Congress could tell the states under the Voting Rights Act, here's how you have to manage your elections, Congress can intrude on their sovereign immunity and allow them to be sued. Let me say that one more time. Under Section 5 of the 14th Amendment, Congress can intrude on state sovereign immunity and even waive that sovereign immunity to allow the states to be sued by citizens. In effect, Section 5 of the 14th Amendment creates an exception to Hans v. Louisiana. It creates an exception. Under the 11th Amendment, states cannot be sued except where Congress waives it for them. Right? Congress, in certain circumstances, can waive a state's sovereign immunity. If you want to be fancy words, abrogate. Congress can abrogate or waive. A-B-R-O-G-A-T-E, abrogate. Congress can waive or abrogate a state's sovereign immunity under very specific circumstances. And that's what it attempted to do with RFRA. With RFRA, Congress said, these violation of religious liberty is such a big deal, we're going to waive a state sovereign immunity for it, whether it wants to or not, and we're going to allow them to be sued in federal court. Everyone get that? This is one of the trickier concepts in the class. It's going to get more trickier, but this is actually one of the trickier cases. Boerne was such an important case for a lot of reasons. Okay? So the general presumption is Texas has sovereign immunity, but the federal government can waive it if there's some constitutional violations going on. But we'll discuss the specifics in a moment. Yes, ma'am.
So procedurally, do you just bring a suit against the state and hope for the best, or do you have to like go, how do you get approval for a
You don't need approval.
waiver or like?
You don't need it. So, well, RFRA was found, RFRA was invalidated, right? But had it been upheld, you would just go file a lawsuit against the city of Boerne.
And it would automatically be okay because.
Because the federal courts would say we have jurisdiction.
Okay.
You don't need permission from the United States. You just go and sue.
And then if for some reason it isn't okay. then-
Well, that's how this case came up, actually, right? So the city, so Flores was the archbishop, I think, right?
Yes.
Flores sued the city of Boerne, right? The city of Boerne replied saying, hey, you can't sue us. There's no jurisdiction. Boerne says, listen, we, Texas, I think Ted Cruz may have filed a brief in this case when he was this. No, he wouldn't have been there yet. But Texas filed a brief saying, we do not consent to the suit. We did not waive our sovereign immunity, and you, Congress, cannot do it for us. Only we. Don't mess with Texas, right? Only we can waive our sovereign immunity. Everyone get that much? Okay? So that's what Congress was trying to do. They were trying to find a way to waive state sovereign immunity under their Section 5 powers. But there were two things about this the Supreme Court really didn't like And that's why RFRA was invalidated as applied to the states. I'll mention this briefly. RFRA was invalidated to the states, but not the federal government. If the federal government wants to bind itself and allow itself to be sued, that's fine. So Hobby Lobby versus Burwell, last year's case, this was a federal Obamacare law and suing under RFRA from Hobby Lobby, right? So RFRA exists against the federal government, no problem, but it does not exist against the states. Okay, but let's go back to the states for a moment. Caleb, there are two biggies, but what was one of the big problems with RFRA that Congress, according to the Supreme Court, messed up?
You talked about the compelling government interest and projects.
Why is that a problem? Why is that a mess up?
Because they have to have that in order to be able to act on it.
No, I'm thinking of. Do you have it, Brandon? What's one of the big mess ups that the government, the Congress made here?
They're thinking that Section 5 is more of a remedial or preventative thing and not a substantive, take for account.
Okay, good. Let me digest that for a moment, right? Caleb, Brandon, let me ask you this question. Who gets to decide what the meaning or the substance of the First Amendment is? The Supreme Court or Congress? Oh.
Supreme Court?
Says who?
Constitution?
No.
Oh, legislature?
No. No. And we've done this question a couple times. I heard someone yell at Marshall. You were right. Where in the Constitution does it say that the court is the branch that decides what the Constitution means? Does it say that anywhere in the Constitution? Anyone? Does it say anywhere in the Constitution that the Supreme Court decides the meaning of the Constitution? No. I mean, John Marshall explained why. Well, judges have an oath to the supreme law of the land, therefore we decide what the supreme law of the land is. Maybe, but it says nowhere in the Constitution what the First Amendment means. Let's go up there to Juan. Juan, why can't Congress decide what free exercise of religion is?
Because since it's in the Constitution, not to impose on religion.
Yeah, but why the courts have the power? Why can't Congress decide?
Because they have the power to say what the Constitution.
Where did they get that power from?
I'm not sure, was it delegated to them or?
More like a suit, right? So here's the rub. Since at least times of John Marshall, the Supreme Court's taken the position that the justices decide what the Constitution means, period. And if Congress disagrees with them, tough luck, right? So, is it Mitchell? Mitchell, let me ask you this question. What if Congress decides the Supreme Court messed up? Let's take the Peyote case for an example, right? What if the Congress says, listen, you guys messed this up. This imposes a really big burden on this Native American guy. He can't, do his religious ritual. We're going to provide additional constitutional protections to people. What's wrong with that? What's the problem there?
They would be exceeding the Congress's power.
Says who? Who says that they're exceeding their power? Obviously. Who's writing the opinion? Oh yeah, our overlord, right, Justice Kennedy. It's the funniest thing with Justice Kennedy. When he speaks, the entire court just gets silent. It's like he spoke maybe 20 minutes in, and everyone just got, "What's he gonna say?" Oh my God! It's like Moses at Sinai. We have to receive the law. Something like that. Anyway, I'm going to hell. So, so the court, Justice Kennedy, fittingly, assumes for itself that we decide what the First Amendment means, right? So let's go back, page 50. Go to your Constitution, Section 5. It says, Congress shall have the power to enforce by appropriate legislation the provisions of this article. What is this article? right? Brett, what's this article? What are they referring to? What's this? I mean, it's section 5 of the. So what's this article? Yes, the 14th Amendment, right? Congress has the power to enforce the provisions of the 14th Amendment. Okay. Let's see. William, is there anything in the 14th Amendment about freedom of religion? There's not. So why would Congress have any power at all to discuss freedom of religion under the 14th Amendment?
Is it the appropriate legislation to kind of go forward with enforcing the laws that you want to do?
So let me ask you a follow-up. In the last class, remember I discussed how the Privileges and Immunities Clause was meant to extend the Bill of Rights to the states? But that didn't happen. What happened instead? I mentioned people. No, remember?
The Privileges and Immunities Clause?
Yeah, they killed the Privileges and Immunities Clause.
It's privileges or immunities, which they switched it to.
No. Remember? So today, right? Can Texas ban free speech today? Why not? Under the doesn't the First Amendment say Congress shall make no law restricting freedom of speech? Why are the states bound by the Bill of Rights?
Because the federal government has ultimate power.
No. Luis, why are the states bound by the Bill of Rights?
You cannot infringe, since the Constitution is the supreme law of the land. If they do that, that will be encroaching in the constitutional rights.
I'm looking for a specific clause. You know?
Well, I think it's because the 14th Amendment incorporates.
Yes. What's this word incorporates? What do you speak of? It's exactly right. But what's incorporates mean?
It's, well, you mentioned that the Bill of Rights only applies to the federal government.
Right.
And so what the 14th Amendment did, this created a problem because the states could get away with not ensuring the Bill of Rights. And really, no one really going to stop them. So basically, the 14th Amendment was a way for the federal government to enforce, to make sure the states are following.
Very good. So why don't you look at page 48, right? Flip a page. Section 1 of the 14th Amendment. It says, no state shall deprive any person of life, liberty, or property without due process of law. All right, back up top. Rob, you're up. Rob, what does this word liberty mean in the 14th Amendment? What are some of these freedoms we have? Where do you think they're listed? Yeah. So follow me here, okay? We'll do this later when we discuss the Bill of Rights, but for now, what I want you to know is this. Over the course of 70 years, it's come a while, the Supreme Court said that this word liberty in the 14th Amendment refers to the provisions of the Bill of Rights. And one case at a time, the court said, free speech is liberty. The states cannot violate it. Freedom of religion is liberty. The states cannot violate it, right? The Fourth Amendment right of search and seizure is liberty. The states cannot violate it. So one by one, each of the provisions of the Bill of Rights was incorporated into the 14th Amendment. Like incorporated by reference, as if this word liberty embraces almost all the provisions of the Bill of Rights. So virtually the entire Bill of Rights has been subsumed into this word liberty, right? So when we say in Section 5 that Congress has the power to enforce the provisions of this article, we're not just talking about the 14th Amendment by itself, but all these other rights incorporated therein. Everyone get what I'm saying, right? That all these other liberties were incorporated to the 14th Amendment, and Congress has the power to enforce them. So if a state is violating a person's, free speech rights, Congress can pass law to prevent that. If a state's violating someone's religious liberties, Congress can pass laws to prevent that. Congress can pass laws to allow private lawsuits in federal courts. Everyone gets that. But where Congress went wrong here, according to the court, was that Congress defined what the First Amendment means. Congress tried to define what the First Amendment means. The Supreme Court said, no, that's my job. Go away. Basically, it said it's for us to decide what the First Amendment means, not you. Congress, you cannot define First Amendment rights. That's our job. It's like a union, right? It's a cartel. It's like, get off our turf. It's like a bunch of longshoremen, right? So we have this holding that Congress cannot expand constitutional rights. Because that would turn the Constitution into mere legislation. That's only for the Supreme Court to decide. Now, you may be uncomfortable with this, how 9 judges who are not elected have more of a say of what constitutional right means than the Congress and the president. And a lot of people think this case was very, very wrong, but it exists with us today. So we're going to get that aspect of the holding. That Congress can't define First Amendment rights, only for the court to do it. We won't get that much. Okay. The second part of the case is actually what Brandon mentioned a couple minutes ago. The court can't create substantive rights. They can only remedy constitutional violations. They can only fix stuff that's broken. Okay? And they put forward this test that will not make sense to you at first, but I promise I'll make it a little bit more clear. Okay? Congress can't do anything to fix any problem. Right? The solution that Congress chooses must be very narrow. It must fit the problem. So to give you an example, right? Here's an easy example. If a state is denying blacks the right to vote, right? Because they're putting up all these laws and make literacy tests and whatever, poll tax and whatever other things, right? It's a fairly narrow solution for the court to say, okay, we're going to supervise your elections, and we're going to make sure you're not using these poll tax and literacy clause, right? Everyone get, there's a good fit, right? There's a problem. The solution from Congress is to supervise the elections, whatever, right? Congress isn't saying, okay, we're going to come to your state and take over your entire, state secretary or whatever, and we're going to dictate all their jobs. No, it's saying we're going to focus on the problem. Okay? So what's the issue here? Congress said there's a problem of minority religions being, persecuted, right? The guy with the peyote, he wanted to smoke. So rather than passing a law that says drug laws shall not be used to terminate someone as part of their religion, right? That would have been a narrow solution, that you can't terminate someone for drug use if that's part of their religion, right? That's not what Congress did. They didn't pass a narrow law. They passed a broad law. And this law basically said, if anyone substantially burdens your religion in any context for any reason, go to federal court. Go to federal court. Sue them. So everyone see the difference. There's not a close fit between the problem to be addressed and the remedy. So the phrase the court uses to describe this, I like close fit. That makes sense to me. But the phrase the court uses is, quote, congruence and proportionality. Write that down. Congruence and proportionality. What the heck does that mean? Ask Justice Kennedy. But I'll do my best, right? It means a close fit, right? It's a fancy way of saying how close is a fit. So you have some sort of constitutional problem, right? This guy was fired for smoking peyote. Okay, so a good law would have been you can't fire someone from a job if they're smoking, doing drugs for religion, right? That's narrow. But instead, they passed a law allowing a church to sue a city for not giving a zoning permit, right? There's such a wide gap between the problem and the remedy that they said this is not remedial legislation. It's substantive. Therefore, it's not congruent proportional. It flunks, RFRA flunks the congruence and proportionality test. You can't move too far to fix these injuries. Your remedy must be very narrow. Otherwise, you're going too far to infringe on state sovereignty. States have the power to decide their zoning laws. If the city of Boerne wants to make a historical district, generally speaking, that's to screw over a lot of people, right? What if you want to build something there? You can't. It's historical. So the states have this sovereignty, and it cannot be waived. They cannot be allowed to be sued unless there's a very good reason for it. Okay. Questions? This is one of the trickier concepts. I'll repeat it again in a second, but I'll stop for questions. Yes, sir.
The states can waive their own.
Oh, always, yes. But Texas in this case didn't. Right? Now, what's interesting, and this actually happened, Texas passed its own Religious Freedoms Act. Texas has its own religious freedom. It's called a baby RFRA, right? Texas has one. And you can actually sue Texas under this law. So even though the federal one was invalidated, there's still law that you can sue in Texas court. Yes, ma'am.
Could Congress argue that they're addressing multiple related issues with one law? Like, it seems to me like it would be sort of, it would waste a lot of time to pass a lot of really tiny specific laws, and it would be complicated for the states to interpret, rather than, okay, so we have all these issues with religious freedom within the states, and we're going to try and pass one law to cover them. Could that help get them past the congruence and proportionality test?
So that's actually the point made in the dissent. The dissent was not in your book, but that was the point made by the dissent. The dissent saying, like, listen, why does Congress, why are we forcing Congress to pass all these specific laws, right? Why can't Congress pass a general religious freedom law and we'll let people figure it out? And what the majority says is, no, you need this congruence and proportionality. You need to have the problem and the solution with a close fit. You can't have this wide range of things. Otherwise, we're allowing churches to sue for denial of zoning permits, right? If I lived in San Antonio and I wanted to build on the Riverwalk, I'm not going to get my permit. But from a church, all of a sudden, now you go to court. And now the city may lose. And that intrudes on a core aspect of state sovereignty. Other questions? This was a revolution in constitutional law, right? This is what's often called the Rehnquist Federalism Revolution. The Rehnquist Federalism Revolution, where during the 1990s, you had all these cases. Because look, you had Boerne v. Texas, right? You had Lopez, you had Morrison, you had New York versus United States, you had Prince. In the span of basically a decade, you had half a dozen federalism cases that significantly changed the power of the federal government and restored a lot of power to the states. Because with this case now, the core holding is Congress cannot waive a state's sovereign immunity unless the solution is proportional to the problem, right? Congress cannot waive a state's sovereign immunity unless the solution is congruent and proportional to the problem at hand. So in the same way in Lopez, right, the Supreme Court said, in order to ban guns in a school zone, you need to have a finding that guns impact interstate commerce. Here too, they said, you need to show how this problem will be fixed by this solution. And if it's too broad, if it's not proportional, unconstitutional. So if we get the holding of Boerne v. Flores. Oh, funny thing, Justice Kennedy accidentally said South Carolina v. Dole. I was like one of 3 people noticed it. Yes, he said South Carolina v. Dole. It's South Dakota v. Dole. Anyway, speaking of states. Even he makes mistakes. Even Moses, has to smash tablets like, Mel Brooks and get new ones. 10 commandments. You want to get the joke? History of the World Part 1? Anyway. All right, so that's the holding of Boerne, right? That if Congress wants to waive a state's sovereign immunity, the solution must be proportional to the problem. And it's the court, not Congress, who defines the meaning of the First Amendment. And Kenny's like, don't forget it. This is my job. Get off my turf. Get off my lawn, kid. Yeah.
Did Scalia just write his concurrence because he was mad at the dissenters for getting mad at him, his opinion from
Smith?
Yeah.
Probably.
Okay.
He was very ornery yesterday. He was in good spirits yesterday. There was this one funny part, though, you'll appreciate. So they were talking about Obamacare, and you know, if the court invalidates this rule, a significant number of people may lose their coverage. And then so Justice Scalia said, well, couldn't Congress fix this, right? And the Solicitor General, Don Verrilli, the top government lawyer, said, this Congress? Like, you kidding me? He said, like, theoretically this Congress. And then Justice Scalia shot back at him and said something like, I don't care if it's this Congress or any Congress. If there's a big problem, Congress can fix it. And it was an interesting point. See, I think the Solicitor General, whom I respect a lot, messed up. I don't think the government lawyers should be making these kinds of political arguments to the court. Like, it's of course obvious. Anyone who reads a newspaper will know what's going on. But I think this was below the court. But Scalia's like, I don't care if this Congress could. It's not for our concern. If there's something unconstitutional, we can invalidate it and let the court fix it. I'm sorry, let the Congress fix it. But this was the little fireworks yesterday. There were a couple of fireworks. Very interesting argument. Right, any more questions on Bernie? Okay, let's do the last case. The last case is Morrison. So we already discussed this case in the context of the Commerce Clause, and you'll recall that this was a case involving a female student at Virginia Tech, Christine Berzoncala, who was she alleged she was raped and assaulted by these two guys who were on the football team. Okay, and may not come as much a surprise to you. Let's say the school wasn't very diligent in prosecuting these individuals. Ultimately, I think maybe one of them was suspended for a semester or 2 semesters and it got cut in half or something, and the other one didn't even get a punishment, if I recall correctly. So, in the first part of the court's opinion, they held that Congress could not regulate this activity. Why? Domestic violence was not a commercial activity. Domestic violence was not a commercial activity, right? Same way that simple having a gun was not commercial activity, domestic violence wasn't. Even though domestic violence impacts the economy, women can't work, et cetera, court disregarded that. But the second part of the court's opinion, concerned VAWA. VAWA is a Violence Against Women Act. And one of the things VAWA did was that it gave a federal cause of action that said you can sue people who are involved in violence, right? You can sue anyone in federal court. So who did Christine Berzoncala sue? Well, she sued her two the accused aggressors, right? And she sued Virginia Tech. Why did she sue Virginia Tech? Deep pockets, right? These were two college students. They didn't have any money, right? She wants to sue the university. Well, you may not know this, but state universities are arms of the state. She cannot sue Virginia in Virginia court. She can't sue the university. So she relied on VAWA to go to federal court to sue Virginia Tech, claiming that it, covered up and brushed aside her investigation. Okay. Yes, ma'am. No, 11th Amendment, you can't sue them in any state. Right. 11th Amendment, you can't sue anywhere. So she said, hey, wait a minute. Congress waived Virginia's sovereign immunity for it. Have had that happen. Well, Virginia was not good at policing violence against women. That's a violation of the Equal Protection Clause for not giving equal treatment to women. Therefore, Congress is able to waive Virginia's sovereign immunity. I'll say that one more time. Berzoncala said, hey, wait a minute, Virginia, you guys are not treating women right. You're not prosecuting crimes against women with violence involved, right? That's unconstitutional, right? Therefore, Congress can waive your sovereign immunity and allow me to sue over this. Okay. What did the Supreme Court say? Awesome. What did the Supreme Court say? No. Hugh? Well, other than the Commerce Clause, could they waive the sovereign immunity of the state? Why not? What's the test we just discussed in Boerne v. Flores? Okay, so let's walk through this, right? What is the alleged injury here? What's the alleged injury by Ms. Berzon-Collins? What is she claiming happened? And what didn't happen? No. What did the state fail to do for her? What did the university fail to do? What? Investigate the crime, right? She claimed that after she was assaulted, the state failed to investigate the crime. That they basically covered up, right? They covered up the crime and they didn't prosecute her. Okay? So there's the problem, right? The problem is that states are not properly investigating and prosecuting domestic violence crimes, right? Hugh, what's the solution? What's the remedy that Congress sought to provide? VAWA. And what does VAWA do? Yes. Okay, good. Very good. So then the question, Luke, right? The question is this. How close is the fit between the failure of the police to prosecute crimes and allowing the victim to sue the state university? How close does that fit?
Not very close.
Why is it not very close? You're right, but why is it not very close? Who is not getting punished here, Luke? Who should be punished? other than the criminals. Who should be getting punished in this case? What aspect of the state? More specific. More specific. No, more specific. Who messed up here? No. Shelby, who messed up here? Police, yes. The people at fault here was the police department for the failure to investigate and prosecute these crimes. The people who messed up are the cops. I mean, yes, maybe the president of the university had, like, you know, I went to Penn State for God's sakes, right? Maybe the president of the university knew something, right, about abuse. I should talk. It was very funny. The day before my interview here was the day that Joe Paterno got fired. That's all anyone wanted to talk about. Like, talk about me, not Joe Paterno. But anyway, I was in my hotel room watching, oh, good, they're riding now. Great. So, but yes, the people who messed up here were the cops. They failed to investigate the crime. They didn't take it seriously. They didn't go after the assailants. Right. But instead of Congress saying you can sue the law enforcement agency, say you can sue the university itself. And what the court said is that's too broad. It's not proportional. It's not congruent to the injury. So this isn't some sort of remedial thing where you're trying to fix a problem. It creates a greater substantive right that intrudes on state sovereign immunity. Oh, my ear just unpopped. Oh, awesome. Okay, good. I woke up at 3 in the morning last night. Like, yes, it unpopped again. Okay. It's the worst feeling when you can't hear. It's like this weird pressure. Figures. So you know, because of Breaking Bad, like you can't buy pseudoephedrine anymore. You have to go like behind the counter. I was at a pharmacy at CVS in like Capitol Hill, and they were basically all out. They had like one thing of Sudafed left. So I'm like, oh god. So anyway, fortunately, at the last one. So this was a law that was not proportional. The solution of allowing Berzon-Collins to sue the state was not a close fit with the injury that she suffered. Therefore, the court invalidated this aspect of VAWA. And the court says at the very end, listen, this is for Virginia to fix, not the federal courts. And the court writes, if the allegations here are true, no civilized system of justice could fail to provide her a remedy for the conduct of Morrison. But under our federal system, that remedy must be provided by Virginia, not the United States. In other words, if Brazancala has a problem with Virginia's law enforcement. She can sue Virginia, right? And Congress can't step in and let her sue the state itself in federal court. They cannot waive that aspect of state sovereignty. So that's the majority opinion. Any questions on the majority? Yes, ma'am.
You know when that girl was carrying a mattress around campus everywhere? Was that like in response to something like this? Because I know that she couldn't, I guess she didn't get justice or whatever she thought.
I'll talk about that after class if you want. Okay. Yeah. Okay. So the dissent, right? The dissent was by Justice Souter. And Justice Souter said basically like, this is ridiculous. Congress made findings that there's this gender stereotyping in many states, right? Congress made specific findings that state police departments are not investigating these types of rape cases. Congress made these findings. How much more specific can you get, right? This is actually Lauren's question before. Why can't Congress take this evidence and say this is probably a national problem and we'll legislate on this nationwide, right? And what this boils down to is the court holds Congress to a very specific standard. They have to act very deliberately and carefully when they intrude on state sovereignty. So here, despite the cost of human, whatever suffering there is, which I'm sure there was in the case of Ms. Brazancala, the court says the benefit goes to, or the tie goes to state sovereignty. If there are any questions, the state sovereignty trumps. Okay?
Is that still like good law?
So there were a couple of cases mentioned briefly in notes afterwards, which somewhat rolled this back, but not really. So the case we have to look at is called 2003, Nevada Department of Human Resources versus Hibbs. Nevada Department of Human Resources versus Hibbs, HIBBS. It's a 2003 case involving FMLA, which is the Family Medical Leave Act, right? And what FMLA says is basically that all employers must give 12 weeks of unpaid leave in case of sickness or whatever. And Congress said that we need this to prevent various gender stereotyping, because if women get pregnant and they have to take off from work, then they're going to get fired, and that's really bad. So we want them to have time off for maternity leave, right? And what the court said was, even though you don't have a constitutional right to maternity, this avoids constitutional violations, right? In other words, by giving women this leave, we are prophylactic. We are avoiding possible gender discrimination. So they said preemptively this is okay. This case was somewhat of a reversal from Morrison, and it's unclear if they're actually consistent. If you want to talk afterwards, we can, but they're not in all fours. But the long and short of it is the congruence and proportional standard still exists, but in Hibbs they found that the standard was satisfied. So in other words, in Hibbs they said that providing women with medical leave is a close fit to this gender stereotyping problem. So in other words, Hibbs applied the Morrison test, they applied the Boerne test, and found that was satisfied. I don't find that persuasive, but those are the relevant cases. Okay. Questions? Any questions? What's in your minds? Anything else? I will see. Oh, Connie, yes.
Talked about being like what the Supreme Court's going to use on this Burwell case that you're talking about.
Which case?
The one that you just went.
Hibbs? Yeah, those are two.
The one that you just went and saw yesterday.
Not relevant. No. No. You can come and talk afterwards if you like. All right, everyone. Have a great day.